Hello, Immigration Nation, and welcome to another edition of Abogada en Vivo. I'm immigration lawyer Nicole Whitaker, and I am here to answer all your questions about immigration, about work permits, green cards, travel permits to visit your home country. And I'm going to start us off with one of the most common questions that I get. And that is, what can I do if my spouse, my husband or wife, who's a U.S. citizen or permanent resident, refuses to file a petition for me, or they just always have excuses and never file, or I'm separated from my U.S. citizen spouse, or I'm divorced from my U.S. citizen spouse? Of course, they're not going to file for me. What can I do now? The good news is that there is hope. There is a way that I help people all the time get a green card on their own without their spouse's help if they're married to a U.S. citizen or a green card holder. So, if you're in that situation, it doesn't matter if you're married to and living with your spouse, if you are separated from but still legally married to your spouse, or even if you are divorced from your spouse within the past 2 years, you might have a way to get a work permit and legal status protection against deportation, a permit to travel to your home country, and maybe even a green card and the possibility of U.S. citizenship in the future. It does not matter if you entered illegally. It does not matter if you have been deported or have a deportation or got caught at the border or had a case in immigration court and you didn't go and now you have a removal order against you. It does not matter if you entered with a visa and you overstayed your visa. It doesn't matter if you have traffic offenses like driving without a license, a DUI, doesn't matter. I have helped people get their work permit, their travel authorization to visit their home country, and a green card through this process, where again, you are applying for legal status without your spouse's help. You don't need their signature, you don't need their help, you don't need anything from them. And this process is completely confidential from them. They do not need to know that you have this case pending. Even if you're married to and living with them, you can keep this case a secret from them. My office keeps everything confidential. The Immigration Service keeps everything confidential. And because of that confidentiality, it typically doesn't cause any problems for your U.S. citizen spouse. A lot of times my clients are afraid that starting this case without their spouse's help will get their spouse in trouble or they'll find out about it, but those things don't happen. The Immigration Service created this program to protect immigrants. And they know that to protect immigrants and give them this way to get legal status, they have to keep the process confidential so that the U.S. citizen or green card holding spouse will not find out about it for the safety of the immigrant. I help men and women. In fact, most of my clients are men married to U.S. citizens or permanent residents. So if you are married to and living with a U.S. citizen or green card holder, if you are married to but separated from a U.S. citizen or green card holder, or if you have divorced a U.S. citizen or green card holder within the past 2 years, give me a call at 410-207-9272. Again, my name is Nicole Whitaker. I am an immigration lawyer, and I am here to help you get your legal status. You deserve a work permit. You deserve a permit to go visit your home country. You deserve a green card. So I'm answering all of your questions right now. In fact, I have several questions. I'm here on Facebook, YouTube, and I'm here on TikTok Live. And I've gotten questions on TikTok Live. So let me answer some of them. We have Jose George asks, Hi, Nicole. What are the chances of getting denied at the port of entry with a travel document? So it depends on um, a couple things. It depends on the type of case that you have pending and your own personal immigration history. So for all of my clients, I consult with them. I ask them questions to make sure that they don't have any grounds of inadmissibility. Make sure they don't have any criminal issues in their history, any issues with drugs or alcohol that might preclude them from getting admitted at a port of entry, even with a travel permit or travel document. So it's really a case-by-case basis. I have had, knock on wood, none of my clients have ever had any problems entering the US with the travel permit that you get when your case for a green card is pending. Depending on how you entered the US and your immigration history, if you have a green card application pending, you could get this travel authorization called advanced parole that allows you to travel outside of the country and then re-enter. So like I said, none of my clients have ever had an issue re-entering, but there's always some risk, however small, because those agents at the airport have a lot of discretion. And definitely if you have any criminal issues in your history or any problems with drugs or alcohol, those could be red flags and reasons for you not to use that travel permit until you get your green card or maybe even US citizenship. Let's see. The real guac getter, I love that, says, I petitioned for my parents. I'm 21. I'm over 21. Our lawyer retired. Will this delay the process? So here is what you need to do. First of all, make sure that that case is pending, that it's been filed with immigration. Make sure that you have receipt notices. They'll say I-797 notice of action at the top, and it'll say the date that your case was filed, and it would be the I-130 and potentially the I-45 for your parents. So make sure you have those receipt notices. If you don't, then your case hasn't been filed probably, and you should talk to another lawyer immediately. If you do have those receipt notices, make sure that immigration still has your address. So even if mail is going to the old lawyer and they're not answering them or forwarding things to you, that you're getting that information. So call the USCIS 1-800 number and they can help you ensure that they have the correct address on file for you and you'll get all of your mail. In immigration, it is super important that you meet all of the deadlines in your case. I have a lot of people that consult with me, and sometimes it's too late. They get a notice from immigration, and then they meet with me 8 weeks later, 3 weeks later, 3 months later, a year later. By that time, it could be too late to save the petition, and either you don't have any chances of success or you have to refile the case and start from the beginning. So whenever you get any notice from immigration, talk to your lawyer immediately. If you don't have a lawyer, consult with a lawyer immediately. It is so important that when you consult with a lawyer, you have enough time to hire the lawyer, gather the documents you need, and then file that response to the request timely before the deadline. Let's see. Can you apply for residency without leaving the US? Larissa is asking, can you apply for residency without leaving the US? Yes, there are ways that you can apply for residency or a green card without leaving the US. In fact, there are many ways. Not everyone is eligible, but that is 90% of what I do is help people get their green cards without leaving the US. There are several ways I do that. There's a program for people that have been mistreated, tricked, abused, physically or psychologically threatened to keep working at their job. There is a way to get a green card if you've been the victim of a serious crime committed in the US that was reported to the police. And there are a few other ways, but another way is if you are married to a US citizen and green card holder. Depending on the way you entered the US, you could get adjustment of status, or there might be a way that you could apply on your own for a work permit, travel authorization, and green card without your spouse's help on your own. So it is kind of fact specific for each case. So if you are wondering whether you are eligible for a green card or just legal status or a work permit, give us a call to schedule a consultation. We still have some appointments available this week, but they're filling up fast. The number you can call is 410-207-9272, or if you're on TikTok, you can click the link in my bio in order to schedule your appointment online on your own. Kay Dang asks, people who are permanently banned, will they be able to come back to the US? So some people have what's called the permanent bar, or they, what's the word I can use? They get the permanent bar, they face the permanent bar if they, after a certain year, I think it's 1995, entered the US after re-entered the US. They accrued more than 1 year of unlawful presence in the US, they left and they returned, so multiple entries. Or they were deported and then re-entered after they were deported. You face what's called the permanent bar. Although it's called the permanent bar, it's actually not permanent. It's only permanent for 10 years. However, the 10 years must be spent outside the US, and you have to file a waiver to re-enter the US after those 10 years. So if you're in that situation, or you know someone in that situation, consult with a lawyer, because it's a complicated process. You do not want to do it yourself, and see if you're eligible. Diana asks, I'm turning 21 this year and want to help my parents get their residency. How do I start? So the first thing you should do is consult with a lawyer. In order for you to petition for your parents and for them to apply for adjustment of status, they must have entered the US with a visa. Even if they overstayed the visa, if they entered the US lawfully with some kind of admission, then you, as a 21 or older US citizen, can apply for them. So if you're in that situation, give us a call, 410-207-9272. I would love to talk to you and your parents, make sure that you're eligible, you meet all the requirements before you spend the time and money applying. Okay, Dan, another note about the permanent bar. So even if someone faces the permanent bar, they still could be eligible to overcome that bar before they spend 10 years outside of the US if they are married to a US citizen. Even if you're no longer living with your US citizen or a permanent resident spouse, but you are still legally married, or if you recently divorced within the past 2 years, there might be a way you can overcome the permanent bar and re-enter the US, depending on your situation. So if you face that situation, talk to a lawyer as soon as possible. It's a serious situation, and you might have options. Another question that I get super often is, I live in Miami, can you help me? I live in Los Angeles, California, can you help me? I live in Houston, Texas, can you help me? Yes, I represent people all over the country. My office is in Maryland, but because immigration falls under federal law, I can represent people all over the world. So it doesn't matter where you live in the United States, I can help you. In fact, more than half of our new clients are all out of the state of Maryland, and of course, because of the pandemic, we are helping all of our clients remotely. So it doesn't matter where you live, we can help you. We have clients in Maryland, Texas, Florida, Pennsylvania, New York, New Jersey, California, Montana, Nebraska, I think even Alaska now. Lots of different states. So many I can't even name them. Let's see. Diana says, what about a visa? And they have been here for 25 years and they both need residency. Yes, Diana, we can definitely help you. Well, let's see. It depends on the situation. If your parents entered without a visa, I'd be happy to consult with them and see what options they have. If they entered without a visa, you are not eligible to do a normal petition for them. They'd have to find a different way. Erica says K1 fiance. Erica, what would you like to know about the K1 fiance visa? There are lots of different facets of the K1 fiance visa. Are you already engaged? Do you plan to get married? Because of the pandemic, I've consulted with a lot of people who would like to bring their fiance or spouse to the United States. And that's the question that they come to me with. If they're not already married, should we do the K1 visa or should we find a way to get married and do the consular processing for a spouse? And there are lots of considerations. So it definitely depends on a couple different things. So it depends on what country your fiance is from. Because of COVID-19, some places are they're not doing certain interviews. So, for example, some places are interviewing and giving visas for spouses of U.S. citizens, but not K1 visas. So, Erica, your plan is to get married for his residence here. So I would encourage you, he's from Mexico. So Mexico is tough because Ciudad Juarez right now is closed. They're not doing any visa interviews. So I would recommend that you give me a call, 410-207-9272 to schedule your consultation with me, and we can talk about your plans, your time frame, and whether it's going to make most sense for you to do the K1 visa to petition for him before you're married, or if it makes more sense for you guys to get married and then file the spousal visa, because there are lots of considerations. When and if you can get married with the pandemic, and then the processing times for each one, and then which consular office would he go to for his interview. Lots of things to think about and make a decision on. So if it's something you're really serious about, give us a call, 410-207-9272. We still have a few consultation slots available this week. I think they're going fast with these a couple Facebook Lives that we've done recently. So I hope that answers your question. Mayvale, I'm not sure how to pronounce that, asks, I have DACA and plan to get married this year. Will it be likely I'll be sent out to Mexico to re-enter? So that's another question where it's probably best if you schedule a consultation with me, 410-207-9272, because there are a lot of different factors to consider. Some things I would ask you is if you entered the U.S. with a visa, if you entered the U.S. at a port of entry or a bridge when you first entered the U.S. So how did you enter the U.S.? If you entered the U.S. illegally without status, just sneaking in across the border, then I would ask you, have you ever applied for advance parole with your DACA so you could leave and then re-enter? I would ask, when do you plan to get married? Because all of those things make a big difference. If you have to leave and go to Mexico and re-enter to do the I-601A waiver, I'd really try to find a way around that, a way other than that, because for a young and healthy couple, it's really difficult to meet the hardship requirements for the I-601A waiver to show that your spouse will suffer extreme hardship beyond that which any couple would experience being separated. Usually it's important to show there's some kind of health, mental health condition that he sees a doctor regularly for. So again, for healthy young couples, it's hard to meet that requirement. And I always try to help clients find a way to adjust their status, get a green card without leaving the country if it's possible. Diana L. Torres asks, is it possible for a case to be an asylum case and now turn into the 10 years? I think what you're asking about is, can an asylum case turn into a cancellation of removal case, which is something you can only apply for in immigration court if you've been inside the U.S. more than 10 years without being placed in removal proceedings before, and if you have a U.S. citizen spouse or child or green card holding spouse or child who would suffer extreme hardship if separated from you. Yes, it's possible. Once your case is in the immigration court, to file cancellation of removal based on having 10 years in the U.S. and meeting those other requirements. If you or a family member is in that situation, I would suggest that they consult with another lawyer to see if there are any other options first, especially if they haven't already filed that case, because it's a really, it can be a really risky thing to do. And just like if you were to get to need surgery, you would get multiple opinions from different doctors before you made a big medical decision like that. You should get opinions from different lawyers before you do something like that as well. Taking so long. Leah, what is taking so long? Your immigration case? Immigration cases. Oh, his DACA case. Yeah, unfortunately, immigration is taking so long right now. Also, the U.S. Postal Service seems to be having issues. We've experienced issues with that where even though immigration sent out a notice, because of the Postal Service, it's taking longer for us to get there. So check and see if your boyfriend's case is within normal processing times. Here's how you do that. So go to uscis.gov or just Google USCIS case processing times. Put in the form number. In his case, for DACA, it's the I-821D. You can look at the processing times for each service center, and you're looking for the renewal, not the initial one. It'll tell you the time frame that it should take. If his case is outside of normal processing times, give us a call, 410-207-9272. I help people all the time whose cases are outside of normal processing times. They waited longer than they should have for immigration, and they need a decision on their case. I've helped people get decisions in as little as 1 month after waiting outside of normal processing times from immigration. So if you're in that position, you've waited so long on your immigration case, give us a call, 410-207-9272. All right, guys. It has been a pleasure talking to you guys. If you have any questions for me, you can send me a private message here and I will do my best to get back to you. I'll let you know if it's something that we can help with or not. And again, my number is 410-207-9272. Thanks for tuning in, and